And Louis, we cover trials all over the country, and I've come up with a little bit of a formula of what a normal jury deliberation is. And I'm not saying this is how long it takes, but this is how long a normal jury deliberation takes. And basically, in almost every state that I've covered trials in, except Texas and Florida, which move much quicker than the rest of the nation, for every week of testimony, it's about a day of deliberations in a normal trial. So if they come in a little bit earlier, I consider it a quick verdict. If they come in a little bit later than that, I consider it a long deliberation. From your experience out there in Illinois, what would be a normal length of a deliberation for a case like this, where you had, what was it, about 5 weeks of testimony, but only 4 days a week, so closer to four weeks of testimony or so, maybe a little bit less? What would be a normal deliberation?
Well, Vinny, the rule that we go by on the defense bar is that if the jury comes back in 1 hour, it's not guilty every time. And that's generally because in a serious case, you're not going to find 12 people who can decide to convict somebody of a crime.
That would be a quick one. That would be a quick one. I'm just trying to prepare the rest of my week here, Louis. What's a normal deliberation?
For a felony case, you need to get typically, if the evidence is overwhelming for the prosecution, you're going to need at least 8 hours to get a conviction.
Okay.
Once you get beyond, you can get a not guilty within 10 to 12. Beyond that, juries seem to tire out rather fast here in Illinois. I don't know what it is. These are good Midwestern hardworking people, but they tend to want to get out of there and go home.
So you'd be surprised if we went past Friday?
Absolutely. The judges around here typically send people home after about let's say 18 to 24 hours. They'll give them an instruction called the prim instruction saying you need to reach a verdict, and then typically that's when it breaks down, and then they say we're split 8 to 4 or 11 to 1, and they'll send a note to the judge. But I've seen judges, they typically send them home rather quickly. I think the key thing in this case actually is that closing argument started this week after Labor Day. So the jury had a 3-day weekend to take it all in and think about the evidence. And who knows, they might have already made up their mind by the time they walk in on Tuesday to hear Chris Koch for the state's attorney and Joe Lopez for the defense. I think that the 3-day weekend is going to accelerate this. I think it's going to move really quickly.
All right, so what I'm hearing from you, Louis, and we've never covered a case in Illinois before because they don't allow cameras, but now they do, but they didn't for this one. It's a long story. We'll talk about it. But let's check the clock, Mike, because right now we're at 37 minutes, 17 seconds. So, you know what? It's early. It's still early. But if they come back this quick, though, I would agree with Louis that. What do you think could be up here? I mean, have you ever seen a 30 or 40-minute verdict in a case of this magnitude?
No, not in a case of this magnitude. I've seen it in much smaller cases, but no, I don't believe this is a verdict. I think it's either that they're asking for items of evidence, or, I mean, it's hard for me to believe they've even picked their foreman yet. In Illinois, the judge tells them, go back and pick your foreman. It's tough for me to even think that they've done that by now, let alone send out notes and start arguing about what they want, transcripts or items of evidence. So this is a little unusual, I have to tell you that.
All right, Louis Gainor, what's your take outside the courthouse in Joliet? We are, less than an hour into this, 42 minutes of deliberations, and the judge has summoned the attorneys into the courtroom.
Well, if you're the attorney on the case, your stomach drops whenever they say there's a note from the jury. Because it's got to be a note asking a question, and the question will always tip you off as to which way they're going, or at least you're going to speculate as to which way they're going. So that's what the viewers should hang on for, is what are they asking about? I'll tell you this, if they're asking to see the transcript of the testimony of Harry Smith, then Drew Peterson is done. It's over. On the other hand, they're probably asking to see a couple exhibits, and this is where the judge plays such an influence on the case. The judge's decision here makes all the difference in the world. If they're asking for exhibits to go back to the jury deliberation room and look at them closely, and the judge says, no, you're not going to look at the exhibits, you've heard all the evidence, you've seen all the evidence, go read the instructions and continue your deliberations, then psychologically the jury is left saying, well, we don't have enough evidence, that's why we asked for it, and that starts to go towards reasonable doubt. So the judge is going to make a big difference here. If he can draw a line in the sand and say, I'm not going to give you any exhibits, just as a policy, or he can start giving the exhibits here and there. But then that becomes contentious because the prosecutor is going to say, we want the ones that help us. The defense is going to say, we want our exhibits to go back. So that's a real question what the judge is going to do. This next note's going to tell us which way the jury's going.
All right, the judge has summoned the attorneys into the courtroom. Beth Karras, we're getting any more clarification of exactly what's happening?
Yes. Now, I had been told that the jurors have to
I'm out of here on an island.
But it doesn't do any good. They're not doctors.
I'm
You
on
can't
an
even get them to
island.
agree.
Louis Gainor, you going to join me on my island? I want the jury to see the evidence.
Well, Vinny, I'm going to agree with you, and I'm sorry if that hurts your reputation. Okay? Listen, this is why not let them see that the facts are? It's the truth. I mean, that's the reason we're here, right? Is to find out the truth. Let them see that the defense. The way that they should approach it is just say, listen, if anything's going back there, everything's going back there, okay? But if we're going to piecemeal this thing, then it's going to be tilted in favor of one side or the other. So either it all goes back or nothing at all. And when it comes to the autopsy photos, you know, the law in Illinois says that if it's too prejudicial, it doesn't go in. Sam Adams is right on that point. But you know, the thing is that the judge can say that it may be prejudicial, but it's still relevant because it shows the injury. That's the whole thing, is that this case is about circumstantial evidence. And so a more conclusive photograph from an autopsy, including peeling the skin back from the scalp or opening up the chest cavity, the judge could find a way to get that back to the jury. And that is a difficult decision to appeal because the appellate court's going to say, we're going to defer to what the trial judge said. It's a matter of abuse of discretion. It's his discretion to let it in. If he thinks it's relevant, it goes in.
Included, I think that helps Drew.
Louis Gainor, you know, I said this yesterday, and I'm still believing it today, that I'm a little more confident today in a prosecution victory here than I was at the beginning of the case. I was more convinced, more confident after the closing arguments than I was after the opening statements.
Vinny, people are going to be disappointed again because I agree with you. This case has gone the prosecution's way. In the last 2 weeks, it's changed my opinion. I'm going to go out there now and I'm going to predict this is going to be a conviction. I think that the prosecution is benefited from the judge's hearsay rulings and the testimony of Harry Smith. When the jury examines all the evidence together, they have circumstantial evidence, but the hearsay statements that they have are very persuasive. That's why lawyers don't want them to be heard in court. We do everything we can to file motions to get them excluded. But the hearsay statements in this case, they're unrebutted. And here's a big problem, is that it doesn't appear that the defense really hammered on this theory, that the statements were never made. It's almost like the defense has acknowledged that they were made, but they're not credible. Well, that's two different issues. If they were made, members of the jury would probably be inclined to believe that they're true. I mean, why would somebody say something like that? So at this point, I'm going to say I think it's going to be a conviction, because the jury's verdict form allows the jury to have some disagreement yet still have a consensus, and that's a problem. What Sam Adams said is true. Generally, as a defense attorney, all or nothing usually works for the defendant, because the conscience of the members of the jury would prevent them from convicting somebody and sending them to prison for life unless they were absolutely sure. They'd rather reach a consensus on a lesser included, like second-degree murder. But in this case, it's almost like that instruction is the lesser included. That's the safety valve that allows the jury to collectively feel that they've done the right thing. And that's my prediction. I think it's going to be a conviction.
All right, we got a lot more to talk about here, folks. We are on a verdict watch. The verdict could...
They got a leader in that room somewhere.
Yeah, Louis Gainor, criminal defense attorney, join us out in Joliet. You know, as a prosecutor, the questions, I was always like, but now in my position here, I love questions because sometimes it can give us a little bit of a snapshot or an inkling as to what this jury is talking about.
Absolutely. We're going to know exactly where they're going with this first question, because they're going to ask for an exhibit or to have the transcript read back to them from one of the witnesses' testimony. And that's going to tell us what they're focusing on. And I really think that we're going to know which way this thing's going to go within the next 30 minutes with this note from the jury. We can know this much already, which is that the group gets along because they wore the color-coordinated outfits, and also apparently they picked a foreman rather quickly, because remember that first question was, can we see exhibits? And the judge told them, no, you have to request them specifically. So they picked a foreperson, and then they were already asking for exhibits at that point. And that happened so quickly that shows that they really are getting to work on this thing, which at the end of the day, no matter which side you're on, prosecution or defense, that's what we're here for, is we want the jury to take this seriously. This is their obligation. They took an oath, and this is what we believe in. This is what makes America a democracy. And so everybody can be relieved that they're taking this seriously. I mean, but you know, I got to warn you, we may be all very disappointed when the question comes back, when do we get to order lunch?
No, well, we're getting close to that hour.
Hold on. Yeah, and that, you know what? And at the end of the day, these are people. You got to feed them to keep them happy. That'll make them work longer. And that's a big part, actually, that, you know, the public doesn't think about. But when you become an attorney trying cases and a judge, we'd also consider this. You have to keep the jury motivated and happy, because we're taking their time. I mean, these are people that have families. They have jobs, and they're really not getting compensated for this. I think the figure is $17.50 a day.
Yeah, and think about the awesome responsibility they have. The awesome responsibility they have in determining what happened. I mean, a mother is dead. 2 children are raised without their mom. The family is grieving. Drew Peters, now they translate the stuff very quickly. Hey, let me go to Louis Gainor, who's also out in Joliet. And Louis, a couple things here. Number one, your take on what the jury wants in this case, and, you know, what does this really mean? I mean, does this really mean that this jury perhaps has decided whether or not this was an accident, and maybe is ignoring the expert testimony in this case and is focusing in on this stuff?
Well, my thoughts are, isn't it amazing that after all these years, it all comes down to Stacy Peterson? That's the first thing they go to, is Stacy Peterson, the witness who's not here, the hearsay for which Illinois lawmakers in Springfield passed a law to target Drew Peterson. I mean, we should have seen this coming, right? This is what the whole case has been about from the beginning, and it's the first major issue the jury is focusing on. So then that begs the question, have they decided already that it's a homicide? Well, if they've discounted the expert testimony, it seems to me that they have decided that it is a homicide. I think at this point, they're going to try to confirm their suspicions. And I'm not saying it guarantees a conviction. What I'm saying is that the jury just wants to make sure that they're right. For them to zero in on Harry Smith's testimony, everybody expected that that would be the most damaging testimony for the defense, and sure enough, that's the transcript that they want to have read back to them. I think this is a big problem for Drew Peterson. At this point, I would interpret it as though that they have decided a homicide took place, that they agree with Dr. Larry Bloom and the state's experts, Mary Case as well. And I think at this point, they're trying to confirm their suspicions. I think the chirping back and forth, that's the issue. Judge White touched on this. If the records show that Drew Peterson and Stacy are calling each other all the time, then that obviously negates that they were chirping. But if it shows that chirping is a consistent pattern, then I'm afraid that that corroborates what Stacy said. And Stacy said this to Neil Shorey. She said it to Harry Smith. It's not just that she said it once. She said it twice to 2 people. And then the jury's going to have to weigh in their minds, well, would somebody ever lie to their pastor? Would somebody lie to their attorney? And those are questions that we're not going to be able to answer. Reasonable minds are going to disagree on that. My view is that the jury's going to say she was telling the truth to the pastor and to her attorney. Why else would she lie to them? She may have had a financial interest in basically extortion, in extorting money from Drew Peterson by threatening to tell the authorities. But the fact of the matter is, if there's one person you would expect somebody to confide in, it would, on that list, I would say a pastor and an attorney in a divorce would